A very good afternoon to one and all. I, Namrata, Assistant Professor at Sri Vaishnav Institute of Law, Indore, feel privileged to welcome you all to the international webinar on Future of Legal Profession with a special reference to globalization. Before starting with webinar, it is humble request from everyone to mute their mic and unmute only when asked for. I now request our Chief Guest, Honorable Justice Sri Deepak Mishra ji, former Chief Justice of India, to inaugurate the webinar by lighting the lamp. We would like to welcome our Chief Guest and speakers by offering bouquet virtually. I request Sri Purushottam Das Ji Pasari, Honorable Chancellor of Sri Vaishnav Vidyapeeth Vishwavidyalaya Indore, to welcome our Chief Guest, Honorable Justice Sri Deepak Mishra ji, by presenting bouquet. I request Dr. Upinder Dhar, Vice Chancellor, Sri Vaishnav Vidyapeeth Vishwavidyalaya Indore, and Sri Girdhar Gopalji Nagar, Chairman, Sri Vaishnav Institute of Law, to welcome our keynote speaker, Professor Dr. R. Venkat Rao, presenting bouquet. I request Sri Vishnu Ji Pasari, Secretary, Sri Vaishnav Institute of Law, and Professor Dr. Vinayak Patnaik, Director, Sri Vaishnav Institute of Law, to welcome our Chief Speaker, Mr. Muhammad Tahir Ansari, by presenting bouquet. I request Sri Girdhar Gopalji Nagar, Chairman, Sri Vaishnav Institute of Law, Indore, to begin today's session by welcoming all our guests and audience.
कानून के क्षेत्र का दायरा विस्तृत हो गया है। हमारे आज के सभी सम्मानीय अतिथि वक्ता अंतरराष्ट्रीय स्तर पर ख्याति प्राप्त कर चुके हैं, जिनका मार्गदर्शन हमारे संस्था के विद्यार्थियों के लिए बहुत ही उपयोगी होगा। मैं यह उम्मीद करता हूं समस्त विद्यार्थियों को कि भविष्य की आपके जीवन में आज का इस वेबिनार में आप बहुत ही लाभ प्राप्त करेंगे और अपने जीवन में इसे देदीप्यमान के रूप में उपयोग करेंगे। इसी आशा और विश्वास के साथ आप सभी अतिथियों का संस्थान की ओर से तथा वैष्णव ट्रस्ट की ओर से हार्दिक स्वागत, अभिनंदन और वंदन करता हूं। धन्यवाद।
Thank you, sir. Now, I request Sri Purushottam Das Ji Pasari, Chairman, Sri Vaishnav Group of Trust and Chancellor of Sri Vaishnav Vidyapeeth Vishwavidyalaya, to address the audience. Sir, please.
नमस्कार। आज के अंतर्राष्ट्रीय वेबिनार के मुख्य अतिथि आदरणीय माननीय मुख्य न्यायाधीश दीपक जी मिश्रा, भारत के पूर्व न्यायाधीश, मुख्य वक्ता प्रोफेसर डॉक्टर आर वेंकट राव, अध्यक्ष विवेकानंद इंस्टीट्यूट ऑफ प्रोफेशनल स्टडीज दिल्ली, भूतपूर्व कुलपति नेशनल लॉ स्कूल ऑफ इंडिया यूनिवर्सिटी बेंगलोर, मुख्य वक्ता श्री मोहम्मद ताहिर जी अंसारी, सॉलिसिटर अंसारी लॉ सॉलिसिटर फर्म, डायरेक्टर सोलोमन लॉ लिमिटेड, मैनचेस्टर यूनाइटेड किंगडम, वैष्णव इंस्टीट्यूट ऑफ लॉ के अध्यक्ष श्री गिरधर गोपाल जी नागर, उपाध्यक्ष श्री देवेंद्र कुमार जी मुच्छा, मंत्री सचिव श्री विष्णु जी पसारी, संयुक्त सचिव श्री राघवेंद्र जी मुच्छा, कोषाध्यक्ष श्री विजय जी आगर, श्री वैष्णव विद्यापीठ के कुलपति डॉक्टर उपिंदर धर जी, श्री वैष्णव शैक्षणिक एवं पारमार्थिक न्यास के समस्त न्यासीगण, संस्थान के निर्देशक डॉक्टर विनायक जी पटनायक, संस्थान के समस्त शिक्षकगण, छात्रगण, समस्त अतिथिगण, मैं आप सभी का वैष्णव ट्रस्ट की समस्त संस्थाओं की ओर से हार्दिक स्वागत करता हूं, अभिनंदन करता हूं। विशेष रूप से आज के वेबिनार में हमारे निमंत्रण में पधारे हुए आदरणीय श्री दीपक जी मिश्रा, प्रोफेसर डॉक्टर वेंकट राव एवं मुख्य वक्ता श्री मोहम्मद ताहिर जी का विशेष रूप से अभिनंदन करता हूं एवं स्वागत करता हूं, जिन्होंने आज यहाँ आकर हमें गौरवान्वित किया है। बंधुओं, श्री वैष्णव ट्रस्ट एवं इसकी सहयोगी संस्था ने गत 137 वर्षों से इंदौर शहर में नर सेवा, नारायण सेवा मंत्र को आधार मानकर जन सेवा एवं जन कल्याण के अनेक प्रकल्प संचालित किए। वर्ष 1884 में इंदौर के वस्त्र व्यवसायियों ने स्वयं के व्यवसाय पर शैक्षिक टैक्स लगाकर श्री वैष्णव सहायक कपड़ा मार्केट कमेटी की स्थापना की। इसका मूल उद्देश्य असहाय बंधुओं तथा जरूरतमंद नागरिकों की सहायता करना, पशु पक्षियों को आहार देना और साधु संतों की सेवा करना था। सभी पूर्ववर्ती संस्थापकों की दूरदर्शिता पूर्ण नीतियों के क्रियान्वयन से फलस्वरूप संस्था द्वारा 1925 में श्री वैष्णव अन्न क्षेत्र एवं श्री रामकृष्ण बाग और 1934 में श्री वैष्णव आयुर्वेदिक औषधालय की स्थापना की। यह औषधालय विगत 86 वर्षों से आज भी संचालित है एवं अब इसमें आयुर्वेदिक के साथ साथ एलोपैथी एवं होम्योपैथी से भी इलाज किया जा रहा है। सन 1951 में श्री क्लाथ मार्केट वैष्णव हायर सेकेंडरी स्कूल की स्थापना की गई। शैक्षणिक क्षेत्र में यह प्रथम विद्यालय था और यह विद्यालय विस्तारित होना श्री वैष्णव ट्रस्ट के इतिहास में टर्निंग पॉइंट सिद्ध हुआ। इसके पश्चात 1962 में श्री वैष्णव पॉलिटेक्निक, 1967 में श्री वैष्णव वाणिज्य महाविद्यालय, 1981 में श्री क्लाथ मार्केट वैष्णव बाल मंदिर, 1987 में श्री वैष्णव इंस्टीट्यूट ऑफ मैनेजमेंट, 1992 में श्री वैष्णव कन्या विद्यालय, 1993 में श्री वैष्णव एकेडमी, 1995 में श्री वैष्णव प्रौद्योगिकी एवं विज्ञान संस्थान तथा 2005 में श्री वैष्णव विधि संस्थान तथा श्री वैष्णव शिक्षा प्रशिक्षण महाविद्यालय प्रारंभ किए गए। सन 2015 में श्री वैष्णव विद्या विश्वविद्यालय स्थापित किया गया। आज इन सभी संस्थाओं में 22,000 से अधिक विद्यार्थी अध्ययनरत है। उल्लेखनीय है कि न लाभ न हानि के आधार पर संचालित ये सभी संस्थाएं अपनी प्रतिष्ठा से संपूर्ण देश और प्रदेश को गौरवान्वित कर रही है। समाज में कानून का उद्देश्य नैतिक पवित्रता को बनाए रखना है जो समाज को बांधती है। इसीलिए कानूनी पेशे को एक महान पेशा माना जाता है क्योंकि यह कानून का रक्षक है। यह एक सेवा उन्मुख पेशा है जिसका उद्देश्य समाज की सेवा करना है। रोस्को पाउंड ने लिखा है कि ऐतिहासिक रूप से इस पेशे में 3 रूप शामिल है: संगठन, शिक्षा और सार्वजनिक सेवा की भावना। न्यायमूर्ति अय्यर ने कानूनी पेशों को शांतिपूर्ण पेशों में सबसे शानदार और आकर्षक कहा है। न्याय के प्रशासन के लिए कानूनी पेशा हमेशा एक महत्वपूर्ण अंग रहा है। कानूनी पेशे के बिना अदालतें कुशलता पूर्वक न्याय प्रदान करने की स्थिति में नहीं होगी। बढ़ती देशों की भागीदारी और घरेलू अर्थव्यवस्थाओं तक अधिक पहुंच के साथ वैश्वीकरण के कारण कानूनी पेशा एक गहन क्रांति से गुजर रहा है। वैश्वीकरण को प्रतिबंधात्मक अर्थों में नहीं देखा जाना चाहिए क्योंकि इसने कानून के छात्रों के शिक्षण में बदलाव लाया है। वैश्वीकरण और कानून के सार्वभौमिकरण द्वारा दी गई चुनौतियों का सामना करने के लिए पेशेवर कौशल को सुधारने के लिए अधिवक्ताओं की प्रशिक्षित किया है। फर्मों या कानूनी पेशे के मानक मानदंडों को बनाए रखने के लिए हमें उच्च प्रोफाइल मामलों को संभालने में सक्षम अधिवक्ताओं की आवश्यकता होती है, जिसकी मांग भारत में स्थापित विदेशी फर्मों और घरेलू फर्मों द्वारा भी लगातार की जा रही है। भारत कानूनी क्षेत्र की सेवाओं को बनाए रखने, विदेशी अधिवक्ताओं और फर्मों को भारत में स्थापित होने की अनुमति देने के लिए प्रयास कर रहा है। कुछ भारतीय कंपनियां अमेरिका, यूनाइटेड किंगडम जैसे अन्य देशों में अपने फर्म की शाखाएं स्थापित कर रही है। यह फायदेमंद है क्योंकि अधिवक्ताओं के पास कानूनी क्षेत्र के विभिन्न पहलुओं के लिए व्यापक दायरा होगा और वे देश के बाहर अभ्यास करने में भी सक्षम होंगे। इन्हीं सभी कारणों के ध्यान में रखते हुए वैश्वीकरण के संदर्भ में कानूनी पेशे के सभी पहलुओं को उजागर करने के लिए इस अंतरराष्ट्रीय वेबिनार का आयोजन किया जा रहा है। आशा है इस वेबिनार से छात्र, अधिवक्ता, शिक्षाविद, शोधार्थी आदि लाभान्वित होंगे। अंत में मैं पुनः सभी अतिथियों के प्रति हृदय से आभार व्यक्त करता हूँ कि उन्होंने अपने व्यस्तम समय में से अमूल्य समय निकालकर इस कार्यक्रम को दिया। धन्यवाद। जय हिंद।
Thank you, sir. Now I request Dr. Upinder Dhar, Vice Chancellor of Sri Vaishnav Vidyapith Vishwavidyalay, Indore, to address the audience. Sir.
Honorable Justice Shri Deepak Mishra ji, former Chief Justice of India, Professor R. Venkata Rao, Professor Mr. Muhammad Tahir Ansari, Honorable Chancellor Shri Purushottam Das ji Pasari, Shri Girdhar Gopal ji Nagar, all Honorable Trustees, August Gathering, and my dear students. If we go back to mid-1980s and before, legal profession used to be the last choice as a career. In fact, I would like to cite from Justice Chandrachud's keynote address at the Harvard Law School Center. I quote, when he said that I must tell you a story about Delhi University when I was a law school, when I was a law student. A very enterprising friend asked me, what are you doing to do after you graduate law school? I said, I'm going to be a lawyer. He said, how are you going to earn your income? I said, from the practice of the law. He said, you belong to a legal family. Why don't you, through your contacts, get a gas agency or a petroleum outlet? I said, what does that have to do with all our learning as lawyers? He said, that is how you are going to make your income as a lawyer. This is what used to be the reality till 1980s, till the national law schools were established. After the establishment of national law schools, the picture completely changed. Today, the legal profession is highly demanding. And if the students are not rigorously trained to meet the challenges of the profession in 21st century, they would lag way behind. Law schools around the world are engaged in training students from diverse cultural and ethnic groups, which is a major challenge. A curriculum that caters to the need of a diversified body of students is extremely essential. The students studying law today are torch bearers and represent the future generation of lawyers who would contribute to the strengthening of legal systems around the world. Their role in shaping and improving society is crucial. Thus, comprehensive training is required. A lawyer is not only looked up to by the members of the society as a bridge between them and justice delivery mechanism, but also as a person who leads the society towards prosperity and peace. Legal education fostered in the law institutes of India, especially the national law universities, is very organized and systematic. But the need is to tune the curriculum to meet the international standards. It is for the policymakers to introduce pragmatic changes in the curriculum in order to make it more dynamic, functional, and up to date. The future of law around the globe is changing. The landscape of the legal profession is expanding exponentially, and the demand of lawyers in all the domains of society is increasing, which was not so 30 years back. So today, the picture is totally different. For ensuring a successful career in law, a law student must train himself not only in law, but in the art of communication and persuasion as well. Enthusiastic and active participation in the activities such as the moot court, legal aid, clinic counseling consultation, and mediation sessions provides an edge to a law student. In India, the youth is filled with passion for learning, energy, and zeal to take an active part in social development. A robust legal education system may play a crucial role in fueling that zeal and fully realizing their immense potential. Because today, brightest of the lot comes to legal education. As a provider of legal education, it is a moral and ethical duty of every law institute to provide a healthy learning environment to the students for catalyzing their growth. Providing them with efficient intellectual resources, world-class infrastructure, and recreational curriculum should be the fundamental aim of every law institute of the country. A module should be specifically designed to instill certain professional traits in the students, such as good oratory skills, analytical and critical thinking, good writing and drafting skills, leadership qualities, and teamwork. A dedicated module on legal research is a must in every law school, which was not so earlier. I have seen those days also when this image was totally different. But today, thanks to our national law schools, one of the best work done by the National Law School, Bangalore, where Professor Venkata Rao has been Vice Chancellor, is outstanding. Systematically conducted research helps students to find and synthesize new knowledge. Career opportunities in law are immense. Lawyer, for example, lawyer, legal consultant, independent mediator, the legal manager in various organizations, and judicial services are some of the most prominent avenues. To excel in any of these areas, a law student requires efficient training. With rapid development in technology and the advent of artificial intelligence era, a new challenge has been posed in front of the legal professionals. As we have seen, technologies entering every profession, in fact, in our lives. And we have seen it very closely in last 1.5 years during the pandemic. We are able to connect to each other because of technology. Thus, it is extremely important for a law student to continuously keep himself equipped with modern tools and techniques. In this endeavor, a functional learning curriculum can play an important role. Those engaged in providing legal education must update their course module to incorporate the recent development in law field. It is reported that India produces the highest number of legal professionals in the world. The concept of internationalization of legal education needs to be adopted. To conclude, the responsibility of improving the quality of legal education and legal system in the country is also on the shoulders of education providers. This duty should be discharged with utmost dedication, intelligence, and professionalism. I would like to congratulate Professor Vinayak Patnaik and his team for choosing a very appropriate topic for this webinar. And we are very fortunate to have Justice Deepak Mishraji and Dr. Rao and Dr. Ansari with us, who will be enriching our knowledge about this profession, about the legal education, how it should be during the times to come. With these words, I welcome all the guests. Thank you very much.
Thank you, sir. Now I request Professor Dr. Binayak Patnaik, Director, Sri Vaishnav Institute of Law, to highlight on the theme of the webinar and introduce our Honorable Chief Guest for this occasion, Honorable Justice Sri Deepak Mishra ji, to please address our audience.
पटनायक जी म्यूट करिए, अनम्यूट करिए पटनायक जी.
A very good afternoon to all of you. Honorable Chief Guest of the webinar, Honorable Justice Sri Deepak Mishra Sir, respected who is former Chief Justice of Supreme Court of India, respected keynote speaker, Professor Dr. R. Venkat Rao ji, respected Chief Speaker of this occasion, Mr. Mohammad Tahir Ansari ji, esteemed Chancellor of Sri Vaishnav Vidyapith Vishwavidyalaya, Sri Purushottam Das ji Pasari, esteemed Vice Chancellor of this Vishwavidyalaya, Dr. Upenji Dhar, our esteemed dignitaries of this institute, Chairman Sri Girdhar Gopal ji Nagar, Vice Chairman Devendra Kumar ji Muchal, Secretary Sri Vishnu ji Pasari, Joint Secretary Sri Raghavan ji Muchal, and Treasurer Sri Vijay ji Agar, and other revered dignitaries of the trust, Principal of the Institute, Dr. Asutosh Bairagi, invitees, dear colleagues and staff, and my most beloved students. I am really very happy today because today is a golden day and an auspicious occasion in the history of this institute. And actually, we are having amongst us the golden trinity with the pioneer, Honorable Justice Sri Mishra ji and Dr. Venkat Rao ji and Mr. Ansari ji. I am really very, very happy. All of you know that change is the truth. Heraclius, a Greek philosopher, said, change is the only permanent thing on this earth. So it is always observed that society continuously changes and grows. Correspondingly, the law, the legal profession has been changing and will continue to change even in future to cater to the needs of the society and to render social justice. We have been observing that the trend today towards change is globalization, digitalization, and specialization. The law graduates and members of legal profession must be adaptive to this change so that they can contribute responsibly to the society. As we all know, the whole world today is becoming virtual and artificial intelligence has become an integral part of the legal profession. This profession has become multidisciplinary, a catch-all profession, touches all professions like engineering, medical science, forensic science, business, and so on and so forth. So I'm not going to check more on this topic because we are eager to listen to our legal luminaries who will highlight on this topic in a greater detail. Now, I'm proud and privileged that I got this opportunity to introduce the leader of legal profession. The leader of legal profession, Honorable Justice Deepak Mishra today. Born on 3rd October 1953, Honorable Justice Mishra hails from the state of Odisha, the place of Lord Jagannath, and he belongs to a highly cultured and intellectual family of Odisha. Really, he is a born genius. Justice Mishra served as the 45th Chief Justice of India from 28th August 2017 till 2nd October 2018. Justice Mishra began his career as an advocate at the Odisha High Court. He was appointed as an additional judge in the same High Court after rendering relentless service of 19 years. He was appointed as an additional judge in the year 1996. But immediately after that, he was transferred to Madhya Pradesh High Court, where he has he was made a permanent judge. That was in the year 1997. And it's very happy moment that in December 2009, Justice Misra was appointed the Chief Justice of the Patna High Court and served until 2010. And then again, he was appointed as the Chief Justice of the Delhi High Court. Justice Misra was elevated to the Supreme Court as an honorable judge on 10th of October 2011 and assumed the charge of that august office, that high office of the Chief Justice of India on 28th August 2017. A former judge of Orissa and Madhya Pradesh High Court, a former Chief Justice of Patna and Delhi High Court, as a former judge and Supreme Court Chief Justice of Supreme Court, I can say that he was a bold and human judge who can face any challenge in silence because he knows silence is the cradle of power. But if necessary, he can also call for attention of all loudly. He, as a judge, delivered judgments in different areas of constitutional law, public interest litigation, commercial law, arbitration, criminal law, and intellectual property law. One remarkable thing which you will remember always, that when Justice Misra was a judge of Madhya Pradesh High Court, he struck down an amendment. He struck down an amendment to the act that provided gradually taking away grant in aid from the aided educational institution of this state. And that particular decision of Justice Misra saved the livelihood of thousands of teachers. So we will not forget Justice Misra. Madhya Pradesh will not forget Justice Misra. There is another very important point that as Chief Justice of from here he was appointed as the Chief Justice of Bihar High Court. So Justice Misra will not also forget Madhya Pradesh because he was appointed there as a Chief Justice of Bihar High Court. But while he was a Chief Justice in Delhi High Court, he did so many things. And particularly one thing which is very, very important, that he directed the Delhi police to upload the first information report on their website, on the police website, within 24 hours of the lodging of the FIR, because it will enable the accused to have access to the first information report and its allegations for filing appropriate application before the court for redressal of the grievances. And the same thing is also confirmed while Justice Misra was in the Supreme Court. The same thing. And he directed all states and union territories to file the FIR on the website. Actually, when Justice Misra was the Chief Justice of Delhi High Court, he, on a public litigation, he directed that the shelter homes in Delhi should run properly. Justice Misra took a humanitarian approach by taking so much of cognizance when a helpless woman died while giving birth to a child on the roadside, and issued directions to make arrangements not only for the child but also to take care of helpless and helpless women. While as a Chief Justice of Delhi, this is one thing to be remembered, that he decided more than 5,000 cases in 16 months. It indicates his hard labor. Then he came as a judge of the Supreme Court. As a judge of the Supreme Court of India, Justice Misra delivered several landmark judgments. He contributed profoundly and immensely to the Indian constitutional jurisprudence. And in each of his judgments, we can say it is a turning point and watershed moments in Indian judicial history, which enhanced the area, the scope of a golden trinity, the golden triangle, that is right to equality, right to freedom, right to life and personal liberty under the Constitution of India. In a historic ruling, Justice Misra partially struck down Section 377 IPC because it criminalized the gay sex, the homosex, but he decriminalized. Why decriminalized Section 377? Gay sex and homosex? It is to only give an opportunity to the transgender people, but not to give a green signal to all to go for a gay marriage. It is misconstrued. So he gave an opportunity, protected the rights of all citizens. There is a saying that take me, I am what I am, and take me as I am. So by the judgment, he protected the rights of the transgender. In this particular judgment, he highlighted on the constitutional principles of transformative constitutionalism. In the enforcement of constitution, he introduced transformative constitutionalism and the constitutional morality. Chief Justice Misra also struck down the century-old section 497 adultery because it was also arbitrary. It was also against women because the males were only allowed to file against women on the event of adultery committed by the woman. It was discriminatory. It was struck down by him. It was struck down by Justice Misra, that 497. And again, in a very important case of Charukh, he lifted the ban. Very important. He lifted the ban on the entry of women into Sabrimala temple and thus voiced opinion against discrimination against women of a particular age group. Again, in the bench headed by Justice Misra, in a very important case of Charukh Rana, by judgment, he gave the judgment which helped the women in the film industry to designate themselves as a makeup artist, which they were not given that designation. So in a unanimous ruling of the Common Cause versus Union of India, the Constitutional Bench led by Justice Misraji recognized the right to die with dignity as a fundamental right. Why? For smoothing the process of dying terminally. For whom? For the ill patients, terminally ill patients. And he allowed only passive euthanasia, not active euthanasia. That is very important judgment which he has given. He also hailed the right to freedom of speech and expression. He stayed the ban on the movie Padmavati by certain states. Chief Justice Misra told that cinemas as an art form are inseparable part of the right to freedom of speech and expression. So the right to choose his own partner is an integral part of right to life and liberty. In a very important case of Hadia versus the Union of India, Saktivaini versus Union of India, he denounced honor killing. He said liberty is nothing but the ability to choose. Liberty is nothing but the ability to choose. So in a path-breaking judgment, Chief Justice Misra, presiding over a constitutional bench, he penned the judgment asking the parliament that you frame the law to ensure decriminalization of politics. Then the most important judgment, midnight judgment, all of you know that Justice Misra rejected the Yakub Menon's appeal to stop his execution, who was involved in the 1993 Mumbai serial blast case. And again, in another verdict, he also upheld the death sentence of the 4 convicts who were involved in this gang rape case, that is the Nirbhaya case. Chief Justice Misra, in his judgments, always condemned mob lynching, mob vandalism, and condemned mobocracy. It is very important to note here that Justice Misra also settled a 120-year-old Kaveri water dispute case, which laid important principles relating to water disputes. He said water belongs only to the government, but therefore the states must share the water equitably. Our water belongs to nobody else but to the government, to the nation. Therefore, every state must share the water equitably. So to be truthful, he was, in short, we can say that he was a warrior of gender equality. And gender justice. He was a strong protagonist of judicial activism and a protector of underprivileged and vulnerable. He said it is the constitution which can unite all the people of India. So pay respect to the constitution. He said people must be judged not by their history, but by their activities. And he always appreciated the wisdom of the young persons. And as I told you, he also struck down the National Judicial Appointment Committee Act because of lack of constitutional validity. He always protected the right to reputation and right to privacy. And lastly, in a last judgment was live streaming of the proceedings of the Supreme Court. It was his last judgment. He said, sunlight is the best infectant. Sunlight is the best infectant. So the proceedings of the Supreme Court must be made open to all. Therefore, we can say he was a judge who has a desire to decide, who is a desire to decide. He is a judge who is brilliant and complete judge. He is a judge with legal pragmatism and the practical, because he is practical always. He was a multi-talented person undertaking every job, whether small or big, and everything you did with commitment and conscience. A great visionary and a human judge, a great poet and author, above all, a good human being and a man of impeccable character, having a pleased disposition, and always a smile on his face, a smile on his face. And to conclude, after serving more than 40 years of relentless service, even now also he is in service, he is serving the community as in arbitration as well as in as a consultant. So we are very, very thankful to you, sir, having present here, and we pray God to give strength so that you can continue to serve the humanity. मैं एक बात बोल के मेरा एड्रेस को विराम देना चाहता हूं, मैं जरूर बोलूंगा क्योंकि वो मेरे दिल में है, जो मैं खुल के बोलूंगा कि क्या कर दिया आपने, ये हमारा सपना था, क्या कर दिया आपने, ये हमारा सपना था, लेकिन कर दिखाया आपने, अभी हम सोचते हैं क्या कोई हमारा अपना भी तो है. Thank you very much. Thank you very much, Honorable Mishra, and I have introduced Honorable Justice Deepak Mishra sir to all of you. Thank you very much. Thanks to all of you.
I request our Chief Guest, Honorable Chief Justice, former Chief Justice Sri Deepak Mishra ji, please sir address the audience.
Sri Purushottam Das ji Pasari, the Chancellor of Vaishnav Vidyapit Vishwavidyalaya, Dr. Upinder Dhar, the Vice Chancellor of the University, Sri Giridhar Gopalji Nagar, Chairman, Sri Vaishnav Institute of Law, Professor Dr. R. Venkat Rao, whom I know for long years, Mr. Tahir Ansari, one of the chief speakers, Professor Dr. Vinayak Patnaik, the director of the institute, Sri Vishnuji Pasari, ladies and gentlemen, and my dear students, whom I always call friends. I have two requests. Please forget the introduction. If you are obsessed with the introduction of Mr. Patnaik, then possibly I will not be able to do justice to the concept. I was really moved what the Vice Chancellor spoke about the modernism of legal profession. While talking about modernism, the National Law University culture, globalization, specialization, energy, and all other kinds of enthusiasm. It is not to be forgotten that the legal profession as a conception can be treated as completely old or completely new. The professionals are required to strike a balance. I'm absolutely certain that there has been a metamorphosis in the legal profession because of the globalization. But that doesn't mean we should ever forget the inherent skills, attitudes, virtues, and the aptitudes required for this profession. The nobility of the profession, the skills in the profession, the articulation of the profession, the value are to be understood in the global context also. I had gone to Bhopal in 2019. I don't intend to name the university. I was attending a valedictory function of a moot court competition. There are so many universities which had come throughout the country. I thought I should attend the arguments in the final round. So I was there along with my wife for 20 minutes. Young, bright students arguing absolutely eloquently. It's not necessary to scan their argument from the perspective of victory or defeat, but how rational they were and how articulate they were and what is being taught to them in the university, that is what matters. Having said that, I have pointed out sometimes there are 5 facets for an advocate to grow in profession. I'll come to the modernity and the modernism. A lawyer or an advocate, there's a distinction, but for the present, let me say in a combined way, whatever he speaks in a court of law, his speech not only have the skill, but he should possess the words of sincerity. If such words are spoken insincerely, without belief, faith, and conviction, that will not carry weight. When I say sincerity, I must explain. If you are convinced it is wrong, you are not to speak so. But if you are convinced the proposition is right, you must speak with sincerity. Do not argue in an insincere manner, despite having enormous skill in your command. Second, as a lawyer, be it a specialized subject in the concept of international law, or good in India, the concept, or a law of our own country. Once you are holding a brief, the best art of advocacy is to anticipate what the other side has in store to argue against you. To elaborate, not that you prepare the brief from your perspective, you must be in a position to prepare from the perspective of meeting the counter arguments. This I would call anticipation of opposition. First, skill with sincerity. Second, anticipation of opposition and thereby preparedness. Third, a lawyer or an advocate in the modern era as well as in the old era is required and was required to give an honest opinion to his client if the client so required. If the client did not require your opinion, but he wanted to file the case, it's the duty of the lawyer to file, because the legal tradition is he doesn't want a lawyer's sound opinion, frank opinion, unless he asks for. He wants the opinion of the court, an opinion of the judge. Here I'll give you an example. I've heard it, but it's the truth. A man from the village came to file civil revision in a particular high court. The lawyer was 80 plus and a different kind. He said, "You have nothing in the case. I will not file." He said, "No, sir. I have merit in the case. You please file. You take your fees." The lawyer was compelled. So he filed. When the case was called, the judge said, "Mr. So-and-so, you have nothing in the case. Look at the wit and look at the frankness." The lawyer said, "My lord, that's what exactly I told my client. But he wants your opinion, your lordship's opinion." And the judge smiled and said, all right, we'll examine the point." What does it mean? The judge's opinion eventually matters, not that you should say, "This is my opinion." That's a legal attitude one has to develop. But it should be a sincere attitude. And in the modern days, I'll explain when I go on further how this has to be done with a lot of empathy, understanding, and knowledge. Then the fourth one, an advocate must understand that he represents a human institution. A court is not a building. A bar association is not just a building. It's obligatory on the part of a lawyer to understand that he is the representative of a human institution, but not a glucometer to test your blood sugar or thermometer to test your temperature. As the Vice Chancellor had told, and Dr. Patnaik has also spoken to some extent, with regard to the concept of modern technology, on which I shall throw light later on, but the institution has to be understood as a human institution. If the institution is a human institution, how do you describe a modern lawyer who are being trained, whom the faculty members present here are teaching? I would like to call them, and I would expect the teachers, all of them are teachers, professors, readers, or lecturers, associate professors, those are designations. In fact, in a Vice Chancellor conference, I had insisted as the head of the system that the Vice Chancellors should also take class. I was addressing the NLU Vice Chancellors that they must also take class, the subject of their choice. So I call them teachers. The teachers must ingrain the idea in a student that when you become a lawyer, a solicitor, a counsel, whatever it is, you are expected to be a human scientist with a progressive and liberal mind. Unless you have those skills and attitudes, you will be deranging the legal profession. We cannot really think of progress. In this context, I would like to apprise the students that there is a book written by a judge. The name of the book is The Seven Lamps of Advocacy. I repeat, it's a very interesting book. I think all of you can read if you have not read. It's a pleasant reading. The Seven Lamps of Advocacy by Edward Abbott Perry. He has devoted a topic to equality. He says an advocate has to be free and must have the grace of and carry the message of justice. And he emphasizes on qualities such as the lawyer must believe in lamp of honesty. He says 7 lamps: lamp of honesty, lamp of courage. He quotes a barrister who appeared in a court and said, whatever has been argued by the other side is absolutely insincere, wrong, and so and so. Everybody was shocked, but he was very well prepared. He was bold. His motto in life was be honest and be bold and be bold. And that's what the judge emphasizes in his book. Then lamp of industry. There is a retired Vice Chancellor of NLU Bangalore, and there is a present Vice Chancellor. All of you must be telling the law students, burn the midnight oil. Here the judge says, lamp of industry. No industry, no fruit. Whether globalization or no globalization, industry is the key word. And you know what he says? You see, people ask you, what is your hobby? What is your habit? Some say gardening, some say XYZ. He says, work must be your habit. Work must be your habit. That is the definition of industry according to the said book. Then he says, lamp of wheat. You see, there is a distinction between wit and humor. He gives an example. Students of law, the members of the faculty of law, all of you must have heard the name of the judge, Lord Mansfield. Lord Mansfield did not care much for the religious holidays. In fact, he was holding court on Ash Wednesday. The bar did not like it. They in fact protested. On one day, he told the arguing counsel that Mr. So-and-so, this case shall be taken up on Friday, though it is a Good Friday. There was absolute silence and a kind of silent uproar. You know what the lawyer answered? The lawyer said, my lord, I have no difficulty to argue the matter, but your lordship will be the first one to hear a case on Good Friday after Pontius Pilate. So Mansfield calmed down and said, no, we'll take it up on Saturday. How wit can move a mind. Then he emphasizes on lamp of eloquence. Here I must clarify, there is a distinction between eloquence and rhetorics. Like there is a nuanced distinction between forceful submission and aggressive submission. A lawyer must make forceful, eloquent submission, but should not take recourse to rhetorics or aggressive submission. Last part he says, lamp of judgment and thereafter lamp of fellowship. That's how you maintain the cordiality in the bar. When he says judgment, judgment of the lawyer. You see, I always told the young lawyers, wherever I went, please put the best point first. Sometimes they come on the third, and by the time the judge might have made up the mind. Anyway, many follow it, many they think they will keep it in the reserve. Having said that, these are the essential requirements which the tradition shows as a laser beam and the modernism also recognizes, because these values, these aptitudes, these qualities can never vanish. Now, the Vice Chancellor of the university was talking about the artificial intelligence. With the globalization, with the modern development, the artificial intelligence has come into the legal world. There are two groups. One who say that we should follow artificial intelligence in great vigor. Others put a scare. I am of the view, follow artificial intelligence. Use it as a tool, but do not be scared of it. An artificial intelligence cannot become an Einstein. It cannot become a Newton. It has its limitations. You must recognize it. The human intelligence is much superior than artificial intelligence. So try to understand and use it as a tool. Second, after this spread of globalization, the country, our country, has really spread with a different kind of elaboration. When I am using the word elaboration, I do not mean any kind of framed elaboration. It is an intellectual and legal elaboration. Many fields have come up where people have written books, people who have joined the legal profession after 95. You see, like books on cyber crime. Unless there would have been development in the cyber field, there could not have been books on the cyber crime and the cyber law. It's very intricate. There are many people who practice in cyber law. They are specialized, and due to God's grace, they make a good name and earn good money. Another aspect I would like to highlight, in the 80s, the concept of insurance law was limited in our country. Now, after it has spread its wings into the international field, now new concepts which have come into our legal regime are insurance, reinsurance, retrocession, and the various facets and aspects of law of other countries, laws of United States of America, United Kingdom, Spanish law, law of Germany. But how do you really understand? You can't be an expert in other laws immediately, but you must have idea and some knowledge so that you can really discuss and participate and sometimes practice. 3 years back, I had gone to NLU Delhi. There was a competition with regard to negotiation. It's a very interesting topic. Anyway, when you hear the word negotiation, you may conceive the idea that it may be one of the stressed facets of alternative dispute resolution system. But that was not the case there. Negotiation means you are representing X, he is representing Y. What are the focal points you have? How can you succeed? How can you convince him with regard to the legal framework which should be made available, and they should also accept mutually without getting into a conflict. It's highly interesting. And this has happened due to globalization. And these young students, some of them confessed before me, sir, we would get into the practice of negotiation. They might have got in their own way, but I'm sure they have got in. Another aspect I want to highlight without taking much time: mediation. Arbitration, all of you know, has taken a global jump. Mediation has taken a quantum leap. There are international disputes. In fact, I must say, I have mediated some international disputes between parties. And I must say, because of the attitude of the parties, and I emphasize the skill of the lawyers and the attitude, the settlement could be arrived at. No one loses. Everyone gets his part of the fees. So these are the tendencies, the trends which are really growing up. We are in a progressive legal regime. In such a framework, the university, which is at Indore, must train its students with all sincerity to grow internationally and grow nationally. They must know the laws of the country and the requisite laws of the international field. Their specialization must be a real specialization. And to achieve that, I can only say they must be humble. Humility is the first step to acquire knowledge. And as I see, the university is teaching with humility. I am delighted and extremely happy to be amongst you in this webinar, and my happiness and delight would have been accentuated had I been physically present at Indore. Thank you everyone.
Thank you, sir. We will take up questions. Any participant having any form of question may ask. Okay. Is there any question? Anyone would like to ask any form of question? Okay, I think we don't have any question. Thank you, sir, for giving your valuable insight on legal profession. It was very enlightening session, and we are sure that this will help every student and every member of legal profession in understanding the concept. Thank you once again, sir. Now, I would like to request Dr. Ashutosh Bairagi Principal at Sri Vaishnav Institute of Law, Indore, to introduce our keynote speaker of the day, Professor Dr. R. Venkat Rao, Chairman, BSLLS and BSES in Vivekanand Institute of Professional Studies, Delhi, and former Vice Chancellor of National Law School of India, University, Bengaluru. Sir.
Thank you, Namrata ma'am. Honorable Chief Guest of the webinar, Honorable Justice Shri Deepak Mishra sir, former Chief Justice of India. Respected keynote speaker, Professor Dr. R. Venkat Rao ji. Respected Chief Speaker, Mr. Mohammad Tahir Ansari ji. Esteemed Chancellor of Sri Vaishnav Vidyapit Vishwavidyalaya, Shri Purushottam Das Pasari ji. Esteemed Vice Chancellor of Sri Vaishnav Vidyapit Vishwavidyalaya, Dr. Upinder ji Dhar. Revered dignitaries of the Institute, Chairman Shri Girdhar Gopalji Nagar. Vice Chairman Devendra Kumar ji Muchal, Secretary Shri Vishnu ji Pasari, Joint Secretary Shri Raghavendra ji Muchal, Treasurer Shri Vijay ji Agar, revered dignitaries of the Trust, respected Director of the Institute, Professor Dr. Patnaik, invitees, colleagues, and my dear students. Good afternoon to all. I am honored to have the opportunity to introduce our guest and keynote speaker, Professor Dr. R. Venkat Rao. Professor Dr. R. Venkat Rao is the chairperson, Vivekanand School of Law and Legal Studies and Vivekanand School of English Studies in Vivekanand Institute of Professional Studies, Delhi. Prior to this, he was the Vice Chancellor of National Law School of India, University, Bengaluru for more than 10 years. Professor Rao's academic qualifications are MA Literature, Master of Law, PhD, and LLD, honoris causa. He has the distinction of serving the statutory bodies of almost all the law schools in the country. He is a member of Board of Governors of Indian Institute of Corporate Affairs, New Delhi. He also served as member Governing Council, Indian Law Institute, New Delhi, and member Academic Committee, Indian Institute of Public Administration, New Delhi. He is also independent director in public sector undertakings like Bharat Electronics Limited, Hindustan Aeronautics Limited, and Goa Shipyard Limited. He is also a member of different committees in Bar Council of India and is associated with prestigious bodies like UPSC, State Service Commissions, UGC, NAC, among others. Sir has received the gold medal for the best PhD thesis, best researcher award from the Andhra University, best teacher award from the government of Andhra Pradesh, best vice chancellor award for outstanding contribution to education during the World Chancellors and Vice Chancellors Congress, Amity Academic Excellence Award twice from the Amity University, Noida for the most distinguished contribution towards propagation of doctrine of knowledge. Professor N.R. Madhav Menon Best Law Teacher Award for outstanding services to the promotion of quality legal education. Attorney General K. Parasaran Award in recognition of his outstanding scholarship in legal education. To date, he has 42 years of teaching and research experience. He has authored 6 books and published more than 130 papers. He has successfully guided 3 LLDs and 20 PhDs. He was the chairman, Board of Governors of Asia Law Institute for the year 2010-11. Sir, we are honored to have you with us today. I request you to enlighten the audience with your words of wisdom. Thank you.
Thank you, sir. I request Professor Dr. R. Venkat Rao, sir, to please address our audience. Sir.
Thank you very much. And sure, the sound is sound. Okay.
Yes,
Because,
sir, that's fine.
Abundant caution being the watchword for legal profession, I always make it a caveat to ask the question, is the light light and sound? Okay. And most revered, my Lord Honorable Justice Deepak Mishra ji, more than the former Chief Justice of India, he was my mentor. He was my chancellor at National Law School of India University. His guidance, his blessings enabled me to meander through the waters of National Law School of India University to the best of my ability. And this afternoon, you have thrown me into the distinguished company of the virtual platform of Justice Deepak Mishra ji. I bow down my head in reverence to Honorable Justice Deepak Mishra and my grateful thanks to the organizers of this function. Janab Mohammad Tahir Ansari ji, Girdhar Gopal ji, the Honorable Chancellor Purushottam Das Pasari ji, my good friend and the Vice Chancellor of the institution, Dr. Upendra Dhar ji, my class fellow, I would say, Dr. Binayak Patnaik, the director of this institution. I can share a secret with His Lordship's permission here. Both Binayak Patnaik and myself have the honor of sharing an honor with Honorable Justice Deepak Mishra of doing our English literature from the state of Odisha. Both of us did from Kolikota College, of course, Sir did from Ravenshaw Institution, and therefore we are in a way buffs of literature. And ladies and gentlemen, I told you that we are buffs of literature, and being a buff of literature, I was in a pensive mood when Professor Binayak Patnaik invited me to deliver the keynote speech this afternoon, that too to be sandwiched between Honorable Justice Deepak Mishra and then Janab Ansari ji afterwards, more or less like a punctuation mark. Therefore, I was in a Hamletian dilemma and I was in a catch-22 situation. But you know, better half is always better than the best. My spouse came to my rescue and she came to me and said, "Why are you in a pensive mood? Normally you would be cheerful." I said, "Mr. Binayak has put me in shackles, whether I should rush where angels would be feeling to tread. I accepting the invitation to deliver the keynote address." Then she said, "Please repeat the word, keynote address." She said, "You come from a family of music lovers. And don't you know, in the world of music, keynote is the lowest note in the instrument. And therefore you are required to perform on the lowest note, go and deliver." That gave me the courage. And with that courage, where discretion would have been the better part of valor, I'm trying to venture to share some of my thoughts on globalization. But after listening to the eloquence of Honorable Justice Deepak Mishra, now I would say you should not say from sublime to ridicule. Okay, but I'm reminded of the famous words of the eldest statesperson of the bar in India today, most venerated senior advocate Parasaranji. And Parasaranji, one day while addressing students of law in National Law School of India University, Bangalore, he was telling, in India, in administration of justice, you have two types of advocates: star lawyers practicing in the Supreme Court and in the High Courts, and then starving lawyers practicing at the grassroots, where 90% of the litigants have the face off. And in India, administration of justice, remember, is to be found in the grassroots system. When we speak about impact of globalization, to what extent globalization would impact the administration of justice at the grassroots and impact the legal profession is highly debatable. And conscious of the caveat, I would initiate my journey. First thing is, Honorable Justice Deepak Mishra's judicious remark on artificial intelligence has brought to my mind the beautiful definition of artificial intelligence given by my lord, a 9th class student from Bombay Public School. She said simply, artificial intelligence means an attempt to mechanize human thoughts is artificial intelligence. But immediately she asked the question, "Sir, can all human thoughts be mechanized?" That left me in a dilemma. It's impossible to mechanize all human thoughts. And recently, I came across a book which I completed it. The title of the book is Artificial Unintelligence. I repeat, Artificial Unintelligence by Meredith Broussard, Broussard. The whole book speaks about the limitations of a computer, the limitations of an artificial intelligence, reminding us of what Steve Jobs in one context said. How happy was the world when Apple and BlackBerry were just fruits. And Steve Jobs himself said, technology is a very good servant but bad master. Therefore, that was so judiciously put by Honorable Justice Deepak Mishra that I thought that I would make a tangential expression to that point before I would speak about the impact of globalization on legal profession. 4 books come to my mind, sir. Three of them authored by Richard Susskind and Daniel Susskind. They speak about the legal profession and the world of technology in the United Kingdom and Europe. And then Stephen Harper, in his book, The Lawyer's Bubble, speaks about legal profession in the United States. And from these four books, I have collected a couple of points to share with you as to how the emerging world of legal profession would be. The first point is, undoubtedly, in the last 35 years, there has been a metamorphosis. There is no doubt about it. And the profession of law has broken the boundaries of the courts and has expanded, as your brochure says, to the world of mergers, acquisitions, corporate firms, law agencies, etc., etc. And certain realms of law which were unknown to us, like cyber law, private international law, and international law, mediation, 95% of disputes are settled in the United States because of mediation, and alternate dispute resolution now becoming appropriate dispute resolution. Remember, these things were unheard of in my days. And most important, the confluence of law, science, and technology. Here I would like to speak to you about one particular point. Today, a popular acronym, STEM, science, technology, engineering, and mathematics. This is the buzzword. But I'm sure in future, this acronym STEM would be changed and become MELTS, MELTS, mathematics, engineering, law in the center state, technology, and science. Because to think of technology and science without law, we will be putting the cart before the horse. Therefore, technology is going to play an important role along with law, and in the future of legal profession, as well as in future of law schools, this needs to be kept in mind. I quote from Richard Suskind's three books are, the first book is The Future of the Professions. It's a masterpiece, how 21st century lawyering will be. Then the second book is Tomorrow's Lawyers, an introduction to the future. The third one is Online Courts and the Future of Justice. All these three by Susskind. I repeat, The Future of the Professions, then Tomorrow's Lawyers, then Online Courts. And the fourth book is by Stephen Harper, The Lawyer Bubble, as to how the bubble is going to explode in the United States very soon. And in Tomorrow's Lawyer, Richard Susskind says, I quote, that the legal world will change more radically over the next 2 decades than over the last 2 centuries. And many commentators have already taken the view that legal profession is on the brink of what we call unprecedented upheaval. And in fact, he says, in the work of lawyers and judges, till 20th century, nothing has changed much ever since the time of Charles Dickens. Charles Dickens used to make reference about law and lawyers in his books. And he says, the setup that has endured in the last 2 centuries has been similar all over the world. And the setup was in support of resolving disputes, or in support of advancing transactions, or in counseling clients on rights and duties. Legal advice used to be handicrafted by only lawyers, often in voluminous pages. Go to any lawyer's office, you will find volumes and volumes of files. And since mid-70s, Susskind says, in some countries, lawyers have started, like the physics laboratory, using a stopwatch in their offices because they charge by hours. That means whatever time you consume, they put the initial reading and the final reading and the charge. This practice has started in the United States in 1970, and therefore hourly billing basis. This has been the pattern in the last 30 years. And therefore, to sort out disputes, also the pattern has been parties congregate before an impartial arbiter, maybe a judge, in a court of law where the process is steeped in tradition and where the language used is, to quote Shakespeare, arcane. Okay, because non-lawyers struggle to understand and follow what is going on. Now, this is the scenario in courts. But today, the court is no more a place. The court is a service, please remember. People have already started asking questions. Is the court a place or the court a service? And today, the change has taken place in such a way that in 21st century, we will be surprised that the legal profession is being liberalized to such an extent that in certain countries like United Kingdom and Australia, you don't need even a legal qualification in law to practice. Very interesting dimension that is taking place. Legal market, he says, has been liberalized so that lawyers do not have exclusive monopoly over legal work. Non-lawyers can own and run legal services. You may call it legal business. While law firms can float on public stock exchanges, that is happening in the United Kingdom. In fact, Janab Ansari Saab will tell you that. And in taking external funding or taking private equity, and you would be also shocked to know that almost 2/3 of the individuals in United Kingdom today, they are preferring to receive help not from lawyers' office and lawyers, but from high street banks. The Cooperative Bank of England is said to be offering legal services from 350 of its branches. That means people are going to a bank branch to take legal services. And it is something like Latin and Greek to us. This is what is happening in 21st century in the United Kingdom. And now non-legal business like telecommunications company and watering associations, they have also come forward to offer legal services. That means in one sentence, thanks to globalization, the solo lawyer is on the eclipse. That's what he says. This is the word he uses. The solo lawyer is on the threat. There won't be now any more one-to-one lawyer and client counseling. And in future, what happens, I quote from the book, he says, you will have hybrid professionals. He uses the word legal knowledge engineer will be the lawyer in 21st century. See, when I joined in a law school, almost the same time, 1972 to 75, people used to say, are you going to become a civil lawyer, criminal lawyer, or a constitutional lawyer? But that's all, now it's gone. And today they say, you have hybrid professionals who have transcended legal boundaries, who are required to speak not only the language of the courtroom, but they will be required to speak the language of the boardroom also. And they are motivated to draw upon the techniques of modern management and information technology. But then he puts the question, how many law schools are teaching these things? He says, you should not teach these things at the expense of constitutional law, law of torts and contract. They must be there. But in addition to that, you are required to speak to them about a legal technologist, a legal knowledge engineer, a legal hybrid, a legal process analyst, then a legal project manager. Because he says in future, the focus would be not on dispute resolution, but dispute avoidance. A very interesting word he coins. The future will be on dispute avoidance and not on dispute resolution. And a very important branch of law called legal risk management will emerge, where the spirit will be on dispute avoidance and towards multidisciplinary practice. Therefore, multidisciplinary practice means you will have alongside lawyers, accountants, consultants, tax specialists, and you will be providing an integrated professional service. Therefore, in 21st century, the day is not far off where you will be having integrated professional service, which is all like Latin and Greek to us. And Janab Ansari Sahib will definitely share with you. And therefore, the impact of globalization on legal profession and the future of legal profession, thanks to the impact of technology, will be such that even tomorrow's employers will be global accounting firms, major legal publishers, legal know-how providers, legal process outsourcers, then high street retail business, legal leasing agencies. Now, this is the trend towards which the world is moving because of the impact of globalization. Already something is felt in United Kingdom and Australia, and they may not be far off when India would be also be bitten by that bug. So this is what I wanted to share with you when I wanted to speak to you about the impact of globalization on legal profession. Apart from the fact that, remember, black coat advocacy is no more the only option in legal profession. That's what we tell always. Intellectual property, patent law, private international, all those things. But 21st century, look 20 years ahead. This is what is going to happen. And this is what Mr. Richard Susskind and Daniel Susskind clearly point out in the 4 seminal books, especially Tomorrow's Lawyers and Introduction to the Future. My sincere request to young student friends and my colleagues is, please go through these 4 books to understand how life of a 21st century lawyer will be. And one sentence it says, in legal curriculum, there must be place for future and not for present, he says. What is being taught in law schools is only present, but not future. And legal curriculum should be so dovetailed that the future must be taught. And the future is here, where the focus would be on legal dispute avoidance and the solo lawyer making a retreat. Now, thank you very much, Dr. Vinayak Patnaik and my good friend and esteemed members of Vaishnav Society for making this afternoon a cherishable one, because I consider today's seminar to be the best Radha Jatra gift that Vaishnav Institute can give to all of us. And may Lord Jagannath bless us all. Thank you very much, sir. Thank you.
Yes, yes. What do you think?
Thank you, sir. I request participants to put their questions.
I have one more observation, Namrata.
Yes, sir.
Now, see, Honorable Ansari Sahib may be waiting. Okay. And therefore, if you have any questions, you can send them to my mailbox. And normally, I don't go to bed without emptying my mailbox. Okay. So that Ansari Sahib, I'll be waiting till the end. After Ansari Sahib completes it, you can put the questions to me. No problem. Okay.
Sure, sir. Sure.
Okay. Because we should not keep our honored guest waiting. Okay. Let's like.
Yes, sir. Thank you, sir. Your address has paved us a way for all of us to understand the legal profession at global level. Now, I would like to request Dr. Ashutosh Bairagi, sir, to introduce our chief speaker for the day, Mr. Mohammad Tahir Ansari, who is Solicitor, Ansari Law Solicitors, Director of Solomon Law Limited, Manchester, UK. Sir.
Thank you again, Namrata ma'am. It's my pleasure to introduce our guest and chief speaker, Mr. Mohammad Tahir Ansari ji. Mr. Mohammad Tahir Ansari is Solicitor, Director, Compliance Officer for Legal Practice in Ansari Law Solicitors at Manchester, United Kingdom. He had been Solicitor Director in Solomon Law Limited, Manchester. Mr. Ansari is law graduate from Punjab Law College, Punjab University. He is postgraduate diploma in human rights from Staffordshire University. He has completed legal practice course from Manchester Metropolitan University. He has also cleared common professional examination from Manchester Metropolitan University. He has been resource person at number of international conferences and seminar and has received several awards for his speeches. He has earned a reputable position with community by helping others in their legal matters in United Kingdom. He appeared on a regular basis on several Sky TV channels to provide general legal advice in live legal programs. We welcome you, sir. Kindly enlighten us with your precious words. Thank you.
Thank you very much for the introduction. First of all, I would like to give my appreciation and also my thanks to Honorable Chief Justice, former Chief Justice of India, Justice Shri Deepak Mishra ji. Also, my thanks to the keynote speaker, Professor Dr. R. Venkata Rao, Professor Dr. Banyak Patnaik, who invited me to take part of this glorious international webinar of the future on the future of legal profession with special reference to the globalization. It is great honor for me to be part of this webinar, and I'm very thankful to all of the team, especially Dr. Professor Patnaik and his team, and my also for the students who are possibly listening to me. It is a great opportunity for all the aspiring students to learn on the globalization of the legal profession, particularly from the point of view where I am sitting here in England, United Kingdom. First of all, whereas the modern communication has developed into the world has become a global village now. And so as the economic development is developing, which introducing, bringing more investments to each countries, such as England, United Kingdom, USA, and also from abroad. I was reading somewhere, and the note was on the Indian development. I would like to quote this, that the globalization has resulted in de facto adoption of international standards in matters such as professional liability, ethics, diversity, non-discrimination policies. It happened to come across, I happened to come across with the article about effect of globalization in India. India is one of the amongst countries that succeeded considerably when initiation and implementation of globalization. The expansion of foreign investment within the field of corporate, retail, and scientific sector in India is gigantic. That is nowadays a need of a globalization because of the development, bringing the globalization into a forum as in one global village to the whole world. जहाँ पे एक बात और मैं मेंशन कर दूं कि हमारे यहाँ यूके में आता है कि जो 3 Ws हैं उनके ऊपर रिलाई नहीं करना चाहिए, हालांकि वो सबसे ज्यादा रिलाई करके उसके ऊपर चलते हैं. I have great respect for women. It's not my opinion, but they say 3 Ws पे आप रिलाई ना करें, जिसमें वर्क है, वेदर है और वुमन है. मैं उस पे ऐड एक और कर दूंगा कि W में 4th भी है जो कि वाईफाई है. ये वाईफाई का कनेक्शन अगर टूट जाए, तो मेरा भी थोड़ी देर पहले कनेक्शन टूटा था, तो मैं थोड़ी देर के लिए आई वाज डिसअपॉइंटेड कि अब कनेक्शन रिस्टोर करने में टाइम लगेगा, मैं मिस ना कर जाऊं अपनी अपॉर्चुनिटी जो मेरी टॉक के लिए मुझे दी गई है. गोइंग बैक टू द टॉपिक, इंग्लैंड में जो ग्लोबलाइजेशन जो है इस वक्त इतनी एक्सपैंड हो रही है बिकॉज द कॉन्सेप्ट has been developing since 1970s. 1970s के बाद ये concept ज़्यादा develop होना शुरू हुआ है. There are multinational firms across the border from USA, from all over the Europe, who are setting up practices in the UK to conduct their practices in the UK. And for that purposes, United Kingdom introduced a Legal Service Act in 1990, and Section 89 of the Courts and Legal Service Act says a person who is not a solicitor of England and Wales, so person who's not a solicitor of England and Wales or a barrister, but who is a member and entitled to practice as such of a legal profession regulated within a jurisdiction outside of the England and Wales, he can become a registered foreign lawyer and he can practice in the UK. So this was introduced in 1990. In 1990, UK government realized that there is a need of multinational companies to go across the border, vice versa. Companies such as big corporate firms, United Nations, USA firms, and they were coming to practice in the UK, and vice versa. United Kingdom practices were going to set up their branches across the border in USA, and so on with the Europe as well. Because the United Kingdom opened their border to Europe, and it was part of the Europe then. They also introduced European registered foreign lawyer as well. So registered European lawyers. So they also gave the opportunity for European lawyers to come and practice in the United Kingdom as a lawyer, not as a solicitor, because they're not a solicitor as such. So they can also then become solicitor once they are registered, move on to register themselves as a solicitor. There is a process to follow, and also there is an exam that you have to sit and become a solicitor or a barrister, whichever field you want to may want to go into. The regulatory body which we have in the United Kingdom, which regulates the solicitors, is the Solicitors Regulation Authority. The body is responsible for maintaining and regulating all the solicitors within the UK. They also set out some principles to deal with overseas registered foreign lawyers. And within those principles, they maintain few things which every solicitor and also registered foreign lawyer must uphold. It says that you act in a way that upholds the constitutional principle of the rule of law and the proper administration of justice in England and Wales, in a way that upholds public trust and confidence in solicitors' profession of England and Wales, and in legal services provided by authorized person. By authorized person, they mean registered foreign lawyer. It includes registered foreign lawyers as well. And they also add, this must be done with independence and honesty and integrity, and in a way that encourages equality, diversity, and inclusion, having regard to the legal, regulatory, and cultural context in which you are practicing as an overseas lawyer. So there are some boundaries when you are coming to UK and registering yourself as a registered foreign lawyer. And you also must follow the procedures in terms of regulatory procedures. And they are obviously in the Solicitors Regulation Authorities guidelines, which can easily be found by the going into the website of the SRA. I was very grateful and also lucky to have to listen to the useful talk of the keynote speaker, Mr. Dr. Venkata Rao. Also, it was a great opportunity for me to listen to Deepak. After hearing them, I think there was only a few things left for me to say in terms of the procedure and if somebody coming to UK and becoming a registered foreign lawyer. India and all the universities in India and also UK universities are now also realizing that there is a need for this globalization, and also there's a need for all the students to have this opportunity to adopt into the modern era of this globalization. So in UK, there are opportunities for the students to go on and learn the law of other jurisdictions. And so, as hopefully, I think the Indian universities are also adopting same procedure for sending their student to UK for studies. I think in terms of since we had this Brexit done, there's more need now in the UK to attract foreign investors, to also attract foreign students, and to also attract skilled workers. Bearing this in mind, the government, the Home Office introduced a few more tier systems and immigration policies, which would enable the investors, innovators, students, and also skilled workers to come into the UK, because the United Kingdom, after the Brexit, has opened their doors to the whole world, rather than just keeping themselves to the restricted to Europe. And that is the aim of the Brexit, and that was the aim the Conservative government, particularly Boris Johnson's. He also had that in his mind, that we should not be restricted ourselves just to Europe, but we should also open our doors to the whole world and attract investors, innovators, and students, and also the skilled workers from all over the world. For those purposes, from 31st of July, the government introduced new legislation in terms of for the students from foreign students, those students who come into UK and studying here and doing their graduation or post-graduation, masters, or their PhDs, they would be able to apply once they've completed their education. They would be able to apply for a visa, which is normally, it used to be a post-graduation visa. They would be able to apply for a visa where they can find work throughout that period. So it's not a visa that they have a job and then they are working as a skilled worker. It is a visa where they will be able to look for a job. So it's a great opportunity for students. I would recommend that anyone who's coming to UK and studying here, completing their studies, and if they want to continue their career in the United Kingdom, it's a great opportunity for them because they will be able to continue their career within the United Kingdom and also look for a job. Once they find a job, then they can move on to the tier system and tier 2, which is a skilled worker. Within the legal profession, there are very great opportunities for students from different jurisdictions, such as India, all over the world, Europe, United States of America, and Canada, Australia, everywhere. So if somebody has done their education in one of the other country, which is overseas countries, and they want to come to UK to practice here in the United Kingdom, I mean, that is obviously part of the globalization, because we are open for the whole world here in the United Kingdom. And if they want to come and do the practice here, they first of all, they need to apply for a certificate of eligibility. once they obtain the certificate of eligibility from the Law Society or Solicitors Regulation Authority, then they can register themselves as a registered foreign lawyer. Once they are registered as a foreign lawyer, they can practice. They can't practice on their own, but they have to be part of the practice where they are working with someone else who's a solicitor in the United Kingdom, either as a partner or as an employee or a consultant. So that's the second stage. If they want to then move on and become a solicitor, then there is an exam in the United Kingdom which is called Qualified Lawyer Transfer Test, which is QLTT. So once they do the QLTT, which is probably one or two paper, depending on their experience, then they can become a solicitor, and they can call themselves a solicitor, and then they can practice without any restrictions within the United Kingdom. So these procedures and these policies and legislations were introduced bearing in mind that we are now a global village where the law is not just restricted to the one country. What my learned friend, Dr. Venkat Rao, said that in early 70s, people used to ask what kind of solicitor you are or lawyer you are, and there was only like one or two options. People would say, I'm a criminal lawyer or a civil lawyer, but nowadays the lawyer is required for everything, for every single part of your life, every aspects of your life. The lawyer is required. A lawyer is required to buy property. Lawyers are required to do businesses. Lawyers are required to do the commercial agreements. Lawyers are required to conduct banking, insurance business. In every aspect of your every aspect of the life, the lawyer is required. And many people have moved on. They've moved on to corporate businesses, corporate lawyers. Rightly said that in the United Kingdom, there is provision that you charge hourly on an hourly rate, and those hourly rates are set on the basis of your expertise. The more experienced you are, the more expensive you are. In terms of going back to the topic with the registration process and all that, my opinion and my feelings are that at the moment there is a real possibility and need of skilled workers in the United Kingdom, because there is a shortage occupation list within the tier systems. Tier system we have in the United Kingdom for visa process, which is tier 1, 2, and up to 5. Tier 2 is particularly for the skilled workers. So if you have, after studying in your own country, if you have any aspiration to come to UK to work, then you are required to go through the tier 2 process. And within the tier 2 process, the shortage occupation, if there is the occupation which is within the shortage occupation list, then you're not required to do or go through a very scrutinized process. You can simply go past and bypass the process and make an application if you find an employer. Obviously, you need to have an employer in the UK who offer you a job as a skilled worker. So these are the opportunities which have been introduced and offered by the United Kingdom for overseas students and also for the skilled workers. In terms of my profession, we in the United Kingdom, as a solicitor, have some boundaries. In our profession, we have barristers, I'm sure you are well aware of the difference between barristers and solicitors. The solicitors are the one who has access to public. We could actually meet our clients. We can take we can take instructions directly from clients, and we can represent our client in the lower courts. We have right of audience in all of the lower courts, except High Court and Supreme Court. The barristers, whereas they don't have any access to clients, but now it's developing, the idea is developing. Many of the barristers are also applying for a direct access. When they're applying for a direct access, they could actually, if they have the permission, they could actually take instruction directly from clients as well. But the solicitors is an intermediary where the barrister is representing client in higher courts, such as High Court and Supreme Court. To balance this, solicitors have also been given opportunity to apply and sit for an exam to become an advocate in the higher courts, and it's called right of audience in higher courts. So equally, if a solicitor wishes to appear before a High Court judge or a Supreme Court judge, then he has to complete that exam. Once he's done that exam, then he can also appear before the High Court. So the law has developed since 1970s. There have been many changes, and particularly where the area where we deal with, such as immigration law. The immigration law is ever changing. We have to keep up to date with the law nearly every day, because there are changes, statement of changes, which is passed by the Parliament and approved by the getting a royal assent and becoming a legislation. So the immigration law is a law where we need ourselves to be updated, not only just immigration, but all laws. But immigration is where there are more changes within the law. So it is my understanding that the legal sector has a direct relationship with globalization. The globalization, if there is a growth in economy, then there is a need for globalization, and that need also have direct impact on immigration sectors. For skilled visas category, the Home Office, for those reasons, has a relaxed threshold for the skilled visas category, so more people can come to the UK to work. This helped the sector where there's a shortage of occupation, a shortage of skilled workers, such as the hospitality sector, and also there's a shortage of the skilled workers within the NHS, such as doctors and nurses, and there are always in demand, and there is always a need for those occupations to come to UK to work. And the relaxation of the rules also acts as an incentive for individuals to immigrate to the UK for work. And these individuals will possibly need legal advice and guidance on their applications, therefore increasing demand in the legal sector for the professionals with expertise and expertise knowledge of immigration law is essential. Therefore, the immigration and migration from one country to another country is also having a great impact on the globalization. The law is not just restricted to the boundaries now. The law is expanding, and the law is it's adoptable, adopting the nature, and also the standards are also being adopted in different jurisdictions. I would be concluding my speech. If there is any questions, you can rightly said by Dr. Venkat Roy that you can come back to me when there is any question. I'm grateful for, and once again, I'm very thankful to all the team of Dr. Patnaik, and also I'm grateful to the institution for giving me this opportunity for a talk. Thank you very much.
Thank you, sir, for giving your valuable practical insight into the profession. And I'm sure that your address helped us in understanding the concept, particularly in the context of globalization. Uh, okay, now since we are done with all the addresses, I would again request our participants to ask questions if they want to. Moving ahead, I would like to request.
I have a question to
Sure,
Mr. Ansariji. What is the position of an Indian who goes to UK for thriving in UK?
Sorry, I missed your question, Dr. Patnaik. If you can repeat the question,
in order to thrive in the UK, can one thrive properly once he goes and practices as an advocate?
Sorry, I think my connection is weak. So your question is that if somebody comes to UK, can he practice in the United Kingdom?
How is the opportunity?
Yeah, opportunity, of course. Yeah, the opportunity is great because obviously due to the possibility of having multinational practices within the United Kingdom, and due to the expansion of the economic growth and development, there is a great opportunity at this stage for lawyers from foreign jurisdictions to come to UK, because there are many cases here where we need some assistance in terms of foreign law, and there is no one here to help. If there is a lawyer from the foreign jurisdiction, because at the global village we have, and there's a diverse society within the United Kingdom. We have people from all backgrounds and people from all societies and people from all countries, and there is a real need because they do have connection in back home in their countries. So there is a real need for lawyers who could possibly provide services in their native country if there is any problem. So there is a need for that, of course. I hope I answered the question.
Professor Venkat Rao said that even now non-lawyers also can go for that.
Yeah.
Can that question be answered by Professor Venkat Rao ji? How can non-lawyers also practice? Will the law it is allowed, or it is only out of the record?
No. Yeah. I'll tell you. Yes.
Whether non-officially they can do or officially also. Will that be acceptable?
Yes, very much officially. Okay. And that's the reason why I'm saying you please read that book. Okay. Now, in England and Australia, okay, the legal market has been liberalized. Okay. And lawyers no longer have a monopoly over legal work. And see, that's it, because this is out-of-box thinking. See, our mindset is so tuned that you must be enrolled as an advocate under Advocates Act, all sorts of things, etc. After obtaining a 3-year LLB degree or a 5-year LLB degree, okay. Now that's what I'm saying. In future, remember, just as geography has become a part of history with globalization, the artificial regimentization of subject-wise specialization would be also becoming a thing of the past. Okay, and that's what he's predicting. And in 21st century, this is going to happen. That's what he says. Therefore, integrated professional services. This is the word he uses.
Okay.
Integrated professional services, and the solo lawyer will not be there. Okay.
Right.
May I just add to this something, if I may?
Please.
Yeah, thank you.
Please.
It is correct. It is correct that if you are a lawyer or an advocate from a foreign jurisdiction, you can come to UK and practice. Practice as a lawyer or advocate, but you cannot call yourself barrister and you cannot call yourself solicitor. And what else you can't do is that you advise someone within the jurisdiction, a law within the jurisdiction of the England and Wales. You can advise on the issues concerning the foreign jurisdictions. There is no prohibition. There's no restrictions. So, for instance, if a lawyer come to you to United Kingdom from India, and he set up his a practice in the United Kingdom to advise people on the issues concerning Indian law, Indian constitutional law, Indian property law, Indian corporate law, or any type of Indian law, he is permitted to do that. There's no requirement for him to be registered with the SRA as a register for a lawyer. But if he wants to practice within the jurisdiction, also advise for the issues concerning UK jurisdiction, then he should register. There are certain restrictions in terms of a few areas, such as, I would say that, I'll just give you one example. It is a criminal offense to advise someone on immigration law, unless you are qualified to advise.
That's right.
Within the United Kingdom jurisdiction. So if you're not a solicitor, if you're not a barrister, or if you're not working under supervision of a solicitor or a barrister, then you cannot advise on immigration law. That is a criminal offense. The pure reason for that is because immigration migrants are very vulnerable people. When they're coming to UK, they are looking for opportunities to settle, and some people they are exposed to some people who will exploit them, and then that's the reason why it is a criminal offense. I hope Mr. Venkatrai will agree with me.
Yeah. Yes.
Okay. Thank you.
Professor Ram must be talking about the future, which may happen like that, because
Yes.
Narasimha Panda raised his hand. I request him to put his question.
Hello, sir.
Yes.
Hi.
First of all, take my pranam to all my seniors, and I am very lucky to attend this webinar. And my question is normally Rao sir. Sir, can the national and international disputes be solved modernizing the law under the system of globalizing the theory of law? Hello, sir.
You are asking me?
Yes, sir. I am. Yes, sir.
Okay. You see, when I said that there was a mediation and a settlement,
Sir.
we arrived at, the one party was from UK, the other party was from India, and they had agreed that the dispute should be governed by Indian law.
Okay, sir.
So when the dispute was going on, they sought my interference, and as the Indian law was applicable, it was quite easy to suggest to both the parties, and the counsel appearing for the UK party very well understood the features of our contract law, property law, and how things take place here. So their main purpose was to avoid further litigation and most importantly, execution.
Okay, sir.
So it could be
Sir,
settled.
another.
Yeah.
Okay, sir. Thank you, sir. Sir, another question is the
Yeah.
constitution be amended in the interest of industries under globalization, sir? Industries.
No. Why to bring industry into the constitution? Tell me, you must express your doubt
No,
in
no,
the,
sir. Uh, Actually, globalization in the law, just I'm in my idea, education law policy, either industries, jo, what it comes under, globalizing. So I'm just asking.
yeah, I understand now. You see, when there is a concept of globalization, and there is many fields are covered in, like law,
Sir.
economics, transactional relationships, industrial perspectives, labor law. So all these branches are covered by statutory law and contract law. So
Sir.
wherever there will be a statutory requirement, the parliament will amend that. That amendment should be in consonance with the constitutional principle. Constitution need not be amended to take in the concept of globalization. It can be argued before a court when a challenge is made that as a policy we have introduced globalization, and that is why this kind of like global tenders are issued. Highly technological aspects are involved. You read in 94 Tata Cellular case what the court says about the constitutional intervention. 2018 and 17, Supreme Court has delivered 3 judgments with regard to multinational participation in the tendering process. You see, there is a committee. That committee is an extremely highly qualified technical committee. There, the role of the court is very narrow. The role of the court is to see whether there is any kind of irrationality or arbitrariness. That's all. In fact, I had interpreted and stated in a judgment, you can find it in 2017 or 18, that the owner, who floats the tender, he is the best interpreter of the tender conditions, unless such an interpretation is extremely arbitrary, imprudent, and inconceivable.
Okay, sir.
Everything must fall to the constitutional framework, but constitutional framework also respects the policy decisions as long as they are not arbitrary, irrational, or not unreasonable.
Sir, if I
Okay.
may add,
Thank you, sir.
Mr. Panda, I
Yes,
try
sir.
to understand your doubt by going to your wavelength. See, normally people in your age group ask me the question, sir, in the preamble there are the words socialist, then you have Article 39 of the Constitution, and how do they go together with globalization and industrialization? Why don't we amend the Constitution and introduce the word industrialization? That may be at the back of your mind. But please read Honorable Justice Deepak Mishra's judgment, a number of Supreme Court decisions where they have given a lucid interpretation about the role of the state. Should it be minimal? Should it be optimal? Should it be maximal? and what do the words connote. Okay, that is where the
Thank you.
transformative role of the court comes, and the brainchild of Honorable Justice Deepak Mishra, sir. Okay, please go through that. Okay.
Thank you, sir. Thank you all. And again, take my pranam.
I should say Jai
Actually, I'm
Jagannath.
very lucky.
Right.
Jai Jagannath. Thank you, sir.
Okay, next question. I think we are done with the questions. I would like to request Sri Vishnuji Pasari, Secretary of Sri Vaishno Institute of Law, Indore, to extend his vote of thanks.
आज के कार्यक्रम के मुख्य अतिथि हम आदरणीय श्री दीपक मिश्रा जी, पूर्व मुख्य न्यायमूर्ति सर्वोच्च न्यायालय का श्री वैष्णव विधि संस्थान एवं श्री वैष्णव ट्रस्ट परिवार की ओर से हृदय से मैं आभार प्रकट करता हूं, जिन्होंने अपना बहुमूल्य समय प्रदान कर हमें हर्षित एवं गौरवान्वित किया। न्यायमूर्ति श्री दीपक मिश्रा जी का आज के विषय वैश्वीकरण के विशेष संदर्भ में कानूनी पेशे का भविष्य पर ज्ञानवर्धक उद्बोधन हेतु धन्यवाद ज्ञापित करता हूं एवं आशा करता हूं कि विधि विद्यार्थी आपके अनमोल वचनों से निश्चित ही प्रेरित एवं लाभान्वित होंगे। अंतर्राष्ट्रीय वेबिनार के प्रमुख वक्ता भूतपूर्व कुलपति नेशनल लॉ स्कूल ऑफ इंडिया यूनिवर्सिटी बेंगलुरु एवं वर्तमान में विवेकानंद स्कूल ऑफ प्रोफेशनल स्टडीज के चेयरमैन प्रोफेसर डॉक्टर आर वेंकट राव जी का हृदय से धन्यवाद एवं आभार व्यक्त करता हूं, जिन्होंने अपनी उपस्थिति से हमें गौरवान्वित किया एवं आज के वेबिनार की विषय वस्तु एवं अंतर्राष्ट्रीय कानून जैसे विस्तृत विषय पर अपने विचार रखे। इस कार्यक्रम के मुख्य वक्ता अंसारी लॉ सॉलिसिटर्स मैनचेस्टर यूनाइटेड किंगडम के डायरेक्टर श्री मोहम्मद ताहिर अंसारी जी को धन्यवाद एवं आभार व्यक्त करता हूं, जिन्होंने इस वेबिनार के माध्यम से यूके से हमसे जुड़ने के लिए समय दिया एवं वेबिनार के विषय पर ज्ञानवर्धक बातें साझा की। आपके व्याख्यान से एवं साझा किए गए अनुभवों से सभी श्रोतागण विशेषकर विद्यार्थी अपने भविष्य को वैश्वीकरण के इस दौर में उचित दिशा पाएंगे। कार्यक्रम में उपस्थित श्री वैष्णव ट्रस्ट समूह के अध्यक्ष एवं श्री वैष्णव विद्यापीठ विश्वविद्यालय के माननीय कुलाधिपति मेरे बड़े भाई श्री पुरुषोत्तम दास जी पसारी, श्री वैष्णव विद्यापीठ विश्वविद्यालय के माननीय कुलपति प्रोफेसर डॉक्टर उपेंद्र जी झा, श्री वैष्णव विधि संस्थान के अध्यक्ष श्री गिरधर गोपाल जी नागर, उपाध्यक्ष श्री देवेंद्र कुमार जी मुच्छाल, कोषाध्यक्ष श्री विजय जी आगार, सह सचिव श्री राघवेंद्र जी मुच्छाल एवं श्री वैष्णव ट्रस्ट के अन्य सदस्यों का उनकी उल्लेखनीय उपस्थिति के लिए आभार प्रकट करता हूं। इस वेबिनार में उपस्थित अतिथि श्रोतागण एवं विद्यार्थियों का आभार प्रकट करता हूं। मैं संस्थान निदेशक प्रोफेसर डॉक्टर विनायक पटनायक जी को इस अंतर्राष्ट्रीय वेबिनार को आयोजित करने के लिए एवं आयोजन के सफल क्रियान्वयन के लिए बधाई एवं धन्यवाद देता हूं। संस्थान के प्रभारी प्राचार्य एवं कार्यक्रम संयोजक डॉक्टर आशुतोष बैरागी कार्यक्रम के आयोजन एवं संचालन में प्रत्यक्ष अप्रत्यक्ष रूप से योगदान देने के लिए समस्त प्राध्यापक गण एवं सहायक स्टाफ का आभार प्रकट करता हूं। अंत में मैं अपने समस्त विद्यार्थियों को उज्जवल भविष्य के लिए शुभकामना प्रेषित करता हूं। धन्यवाद। जय हिंद।
Thank you, sir. I request all to please stand up for national anthem. Thank you all for making this event a successful. Thank you all for making this event successful by marking your presence. We come to the end of the session, and once again, thank you to all our esteemed guests for insightful contribution to this event. Patnaik sir, can we end this session?
So thank you very much.
Namaskar.
Sir, namaskar, sir.
Thank you very much and namaskar to everyone. Thank you.
मिश्रा सर, वेंकट सर, आंसरी जी, सबको
Thank you
मेरा
much. Thank you.
नमस्कार, प्रणाम, धन्यवाद.
Thank you, namaskar.
Namaskar.
Okay.
Okay, participants may leave. Thank you, everyone.